5, 4, 3, 2, 1. The appellant married the daughter of respondent number 1 as per the Islamic rites and customs. Full stop. 2 children were born out of the wedlock. Full stop. Appellant's wife died after 13 years of marriage and within a year he married again. Respondent number 1 maternal grandfather, respondent numbers 2, 3, and 4 maternal aunt and uncles of the minor children, girl aged 13 years and boy aged 5 years, initiated proceedings under section 7, 9 and 17 of the Guardian and Wards Act, 1890 for appointment as guardians. Full stop. They also filed application under section 12 of the Act praying for interim protection of the persons and properties of the minor children and also for an injunction restraining the appellant from interfering or disturbing the custody of the minor children. Full stop. Family court passed an interim order restraining the appellant from interfering with the custody of the children with the respondent. Full stop. Appellant challenged the order. Full stop. Family court set aside the said order of injunction. Full stop. High Court set aside the said order and passed certain directions. Full stop. Hence, the present appeal was made by the appellant in this court. Full stop. Para. Sections 12 of the Guardian and Wards Act, 1890 empowers court to makes such order for the temporary custody and protection of the person of property of the minor as it thinks proper. Full stop. Close. In matter of custody, welfare of the children is the sole and single yardstick by which the court shall assess. The comparative, welfare of the children is the sole and single yardstick by which the court shall assess the comparative merit of the parties contesting for custody. Full stop. Therefore, while deciding the question of interim custody, the court must be guided by the welfare of the children, since it empowers the court to make any order as it deems proper. Full stop. Para. With regard to guardianship, the prima facie case lies in favor of the father as under sections 19 of the Act, unless the father is not fit to be a guardian, the court has no jurisdiction to appoint another guardian. Full stop. Respondents, despite the voluminous allegations leveled against the appellant, have not been able to prove that he is not fit to take care of the minor children, nor has the family court or the high court found him so. Full stop. However, the question of custody is different from the question of guardianship. Full stop. The father can continue to be the natural guardian of the children. Full stop. Para. However, the considerations pertaining to the welfare of the child may indicate lawful custody with another friend or relative as serving his oblique her interest better, full stop. The question of guardianship can be independent of and distinct from that of custody in facts and circumstances of each case, full stop. The court shall determine whether, in proceedings relating to interim custody, there are sufficient and compelling reasons to persuade the court to change the custody of the minor children with immediate effect, full stop. Stability and consistency in the affairs and routines of children is also an important consideration, full stop, para. Keeping in mind the paramount consideration of welfare of the children, the custody of the children which currently rests with their maternal relatives is not disturbed as the scope of the order is limited, full stop. The appellant, in response to these submissions, contended that the High Court could not interfere with the findings of the family court unless serious infirmity is proven, full stop. The decisions cited by the respondents were distinguished on the ground that these decisions concerned findings that were recorded after a full-fledged trial and not an order passed as an aid interim relief granted custody to one of the parties, full stop, para. The High Court in its impugned judgment had held that while appointing the guardian or deciding the matter of custody of the minor children during the pendency of guardianship proceedings, the first and foremost consideration for the court is the welfare of the children, full stop. The factors that must be kept in mind while determining the question of guardianship will apply with equal force to the question of interim custody, full stop. It was observed that the family court should have delved a little deeper into the matter and ascertained where the interest of the children lay, instead of recording abstract findings, questions of prima facie case, balance of convenience and irreparable injury, full stop. The terms on which the appellant and his deceased wife were, the manner in which the respondents obtained the custody of the children are questions that should be determined during the course of trial, full stop. Though when the children's father is not unfit, otherwise he shall be natural guardian, a child cannot be forced to stay with his oblique her father, full stop. According to the High Court, merely because the father has love and affection for his children and is not unfit to take care of the children, the welfare of children cannot be guaranteed, full stop.